Hello, how's everyone doing? Brian Ponder, Brian the Credit Lawyer. Today we're going to do some repo deletion Q&A, and I took some questions from various viewers, and we're going to go through some of them today. If you all have not already downloaded the repo deletion package, it is now available. You can find it in the comments section, or if you're on my Instagram, you'll see it in the bio links. So let's get to some of these questions here. We got some questions from a group on Facebook. Scroll down to it. Shout out to Stephen Palmieri. Some of his followers chimed in on the questions. All right, so here's the first question. The first question says, client had a RV repoed, voluntarily returned to the bank 3 years ago. Bank wrote it off as a charge-off. Can the bank or a collection agency still come after the client for deficiency? What is the best way to get it removed from the credit report? Well, first I want to thank Kathy for that question. So let's break this question up into pieces. So a person had a RV repoed. So RV obviously is a recreational vehicle, one of those big vehicles you can live in. Repoed. And then Kathy says it was voluntarily returned to the bank. So let's break that down. You must understand that a repossession can be voluntary or involuntary. And so this scenario that Kathy is speaking of is voluntary. Voluntary repossession is when the borrower or debtor, so the borrower would be the person that borrowed the money, that put the vehicle up for collateral. That's the borrower. The debtor, same thing. That means that the debtor may or may not have defaulted, but end up turning the vehicle back to the creditor. The creditor would be the person that loaned the money and accepted the agreement that the collateral, the automobile, will be collateral. And so in this scenario, Kathy's saying that the person who had that RV voluntarily returned it to the bank. So that's a voluntary repossession 3 years ago. So 3 years ago may or may not be significant depending on where you are jurisdiction wise, but Kathy put that qualification in there. The bank wrote it off as a charge off. All right, well, let's dissect that. A charge off only means that the bank made an accounting or tax decision to call that, that loan prospective loan income, meaning they expected to get it, but they decided to deem it that it's a loss. A lot of people confuse charge off with discharge. It's not the same thing. The debt is not gone. It's just that the accounting for that particular creditor wrote it off as if it's a loss. They're basically not expecting to get it. They still want to get it. If they were to get it, then they would change their taxation to, that's income that they receive. And this is not tax advice. It may be explained a little differently from a CPA, but in essence, in layman's terms, that's what I'm trying to convey to you. So the bank wrote it off. All right. So the question is, can the bank or collection agency still come after, the borrower for the deficiency? Well, what's a deficiency? So let's break that up. A deficiency is the amount that's left after the collateral is sold. So how do you get that number? So say if that RV was $100,000. RV can be expensive, right? But when the borrower turned it in or voluntarily repossessed it, submitted it to the bank, which is a voluntary repossession, voluntarily gave it back to the bank, if you will. The bank took the RV, sold it at an auction, and did everything right, perhaps, sold it at an auction and got $70,000. You take the loan balance at the time of the voluntary repossession, let's pretend it's $100,000 still. Subtract the proceeds from the sale, $70,000. That equals your deficiency, which will be what? $30,000. And so the question is, can the bank or collection agency still come after the person for their deficiency? Well, the answer to that is it depends. What does it depend on? Well, it depends on whether or not the bank followed the proper law when doing this repossession sale. All right, so I actually have a whole, it's many steps to it, but basically repossession is guided by UCC 9 and Part 6 of that, of UCC Section 9. Before a creditor, a secured creditor. Now, what's a secured creditor? It's a lot of terms. It's a lot of terminology here. So this one question really is a big educational tool for me to explain some things to y'all. So a secured creditor would be that bank. Why is the bank called a secured creditor? Well, they're a creditor because they loaned money. They're secured because that loan is secured by collateral. The collateral is the RV, the automobile, okay? And this is all, excuse me, this is all done by an agreement. So there'll be a security agreement. That security agreement will be built into the agreement for the loan. And we're going to get to another question about that. So after that RV was repossessed, though voluntarily, before the bank sold it under the UCC 9, Part 6, they have to send notice to the borrower of their intent to sell it. And it could be a private auction, a public auction, and their intent to claim a deficiency. Okay, so this has to be done. This notice has to be sent to that borrower before that sale takes place. Some of you may be thinking, well, how long ahead of time does it need to be sent? If you're thinking that, good question, because it has to be sent within a reasonable amount of time. So the law doesn't say it has to be 20 days, 30 days, 10 days, 14 days. It just says a reasonable amount of time. So that's a little gray area, but still, we can understand that a couple weeks or more should be a reasonable amount of time. But if you know, that's for the average person, but we know if the borrower is overseas at war or something like that, that may not be, right? So that's up for interpretation. Now, that's the law. That's a requirement. What if the bank does not do that? Guess what? The bank cannot claim a deficiency. They waive the ability to collect that deficiency, okay? So that would answer that question. What if they did that? What if the bank gave a month's notice, sent it certified mail to the borrower, and sold it for $70,000? Well, now, can they collect on that $30,000 deficiency? It depends again. What does it depend on? Well, after the bank sold that RV, that collateral for that loan, before they can try to collect the deficiency, they have to send notice to the borrower of the calculation of that deficiency. Okay, so it has to explain how the deficiency was calculated. The creditor has to do that before they start collecting. Okay, not after. They can't start trying to collect and then send that explanation after it's asked for. It has to be done before. So if the bank does not send that explanation of calculation of the deficiency before they start collecting on it, well, guess what? The bank cannot legally collect that deficiency. Now, when I say the word legally, because they may still try, again, we understand people can do a lot of things. The question is it legal? So if the bank does not send an explanation of that calculation of deficiency before it starts to try to collect that deficiency, that's illegal. It cannot do it. All right. Let's take it further. What if the bank does it right? Before the bank starts to collect that deficiency, and collection can be sending notices, reporting to the credit report, things like that. Let's say before the bank starts to collect on that deficiency, it line items everything out and sends that explanation to the borrower. Certified mail return receipt requested. The borrower got it, signed for it and everything. Okay, great. That's legal compliance with that requirement. So the next question is, the bank properly sent notice before they sold the vehicle and let the borrower know of its intent to collect deficiency if it doesn't produce enough money. Check. 2, after the bank got the money and applied it towards the loan balance, the bank sat down and line by line item did a explanation of how the deficiency is calculated and sent it to the borrower. Check. Now, can the bank legally try to still come after the client and collect on that deficiency? Okay, it depends again. What does it depend on? Well, was the collateral sold in a commercially reasonable manner? What does that mean? Well, that's up for interpretation. Reasonable is something is an interpretation. So was it sold for way below market value? Was it advertised? Was the sale advertised properly? What I mean by that? Well, did you just tell your, someone on the inside about the sale only, and they came in and bid super low for it so they can be a huge deficiency that they can collect on? All of these things matter. Did you wash the car? Did you leave it? Did you fix the windshield? Did you take the reasonable steps that a prudent seller would to get the maximum value? Is a way I think about it. So that really is one of the final requirements you have to look at. Whether it was sold in, did everything. If the bank did everything else correctly, was it sold in a commercially reasonable manner? All right. So let's say if they did sell it in a reasonably commercially reasonable manner, can the bank collect on the deficiency? Well, the answer would be yes. I could, as many of you may know, say it depends again. Well, how can it depend again? They did everything the law says. Well, was the bank or the entity that sold it the secured creditor? Well, of course they were. They sold the collateral. They repossessed it. That's who the person turned it into. Well, not necessarily. Who is the secured creditor? Well, remember we said earlier, the secured creditor is the person designated in the agreement as the party that is loaning the money and has agreed to take the automobile as collateral. Take a look at that agreement. Is it the bank? If it's not the bank, who is it? If it's someone else, then it may be that person. So maybe this bank was not a secured creditor with the ability to do all these things. A lot of these agreements are actually to the dealership. So if it's to the dealership, how can the bank be the secured creditor? Well, that's a good question. That can be done by assignment. What's assignment? Well, this contract, the security agreement, can be assigned or sold to another entity. So if the entity that's trying to collect a deficiency is not the one that's on the agreement, then you have to determine whether a proper legal assignment took place to give them that position or right. All right, so all of those things have to be considered. So it's actually, that's a good question, Kathy, and I appreciate it. But as you see, it's a lot that goes into that. What I did, I put together a repo deletion package. For those of you that want to take it on yourself, you're able to get this package, and it pretty much has the templates all ready to go that incorporate all of these considerations, so that people can delete the repossession off the credit report and also get these alleged secured creditors to cease and desist trying to collect a deficiency. Because if they don't follow any one of those steps, then they cannot legally do so. And if they try to still do so, they could be at risk for being sued for damages under the Uniform Commercial Code. So thank you, Kathy. That was a good question to start with because it almost laid the foundation to what repossession is. So I appreciate that, Kathy. And so excellent question, Kathy. And it's going to pretty much answer some of these other questions. The other question we have here is from Eddie. Eddie says, would you still have to pay a collection company years later? Well, that depends, Eddie. So you would basically have to consider all the things that I just said. In addition to all the things that I just said, you would also have to consider the statute of limitations in your state. So if everything I just said disqualifies that creditor, the answer would be no, right? Obviously. If they didn't follow those legal steps, then they legally should not and cannot. Well, they cannot legally collect deficiency. What if they completed everything in those steps properly? Can they years later collect on deficiency? Maybe. Now you have to look at the statute of limitations in your state for collecting under such an agreement under the applicable laws in your state. All right. So good question, Eddie. I appreciate that. And we have a question from Brenda. Thanks in advance, Brenda, for this question. What laws can help you remove a repo off your credit reports? Great question, Brenda. Brenda, if you heard the first part, we talked about UCC, and that's the Uniform Commercial Code. The UCC laws can help remove it because that alone really dictates whether a deficiency can be collected or not. All right, so we talked about that. That's one. Two, contract law. Well, where's that? Well, remember, this all has to be done based on an agreement. If there's no agreement, then there's technically no obligation here. So we have to start with the contract law too. Look at the contract. Is there a contractual obligation with respect to this debt, right? And if it's not, then it shouldn't be anything on the credit report. There's no legal obligation here. Two, the Fair Credit Reporting Act. Is it being reported correctly on the credit report? The secured creditor can have all legal rights to collect a deficiency, but if the credit reporting is inaccurate or incomplete, then that could be attacked directly with the Consumer Reporting Agency or CRA to get that deletion off the credit report. So the FCRA, okay, the Fair Debt Collection Practices Act, FDCPA. So that's the fourth law you can look at. The FDCPA applies to debt collectors. So who would be a debt collector? Well, a debt collector would be a collection agency. A collection agency only comes into the picture after there's been a default. Who else could be a collection agency? Well, this new secured creditor that's not the dealership, what if they got the assignment after the person was already in default? Then they would qualify as a debt collector. So, Brenda, great question. You helped me pull out 4 laws that can help remove repo off of credit reports. So that's a great question. I appreciate that. All right, so look, we have expounded on that question. Miles asking, expound on both the CRA disputes and furniture disputes, and how do you set the table for a possible violation? Well, CRA again, the CRA dispute is going to just look at the consumer report to see if anything is inaccurate or incomplete. So that could be anything. It could be the high balance. It could be a late payment. It could be the name of the furnisher. It could be the total number of payments made, the payment amount. Any of those things can be inaccurate or incomplete. So you would attack that as the basis with the consumer reporting agency like Equifax or whoever, and use that to get that deletion off the CRA. So great question, Miles. What about the furnisher disputes? Well, the furnisher has obligations under the FCRA as well to provide that accurate information. So the credit report attack, I would recommend the furnisher utilize some of the the UCC guidelines and try to start there. That's the biggest fish, okay? And if you're unsuccessful there, then maybe look at the FCRA. But when we're dealing with the FCRA, I recommend with a repo issue, just deal with the FCRA with the CRA. Use the UCC with respect to the furnisher and go through the things in my package, my template, to deal with the furnisher through the UCC requirements, okay? And so you get those violations by those things I described, by discovering that they did not do or can't prove that they did any of those steps. So Miles, great question. These are some great questions that we got here. Shayla has a question. Shayla says, I read somewhere that if you have gap insurance and do a voluntary repo, that the gap insurance covers the remaining balance owed. Well, you would have to look at the gap insurance contract to see if that's the case. That will be governed by the contract law. Thanks, Shayla, for that question. Very good question. So sometimes those insurance agreements, you may have to get a lawyer to take a look at it because they're long and is really not as simple to understand as you would think. So in that situation, I would recommend the contract be examined. It's really guided by the contract with that gap insurer. All right, we have a question by Ken, and thank you, Ken, in advance for this question. Can you expound on the steps that the creditors must take before the actual vehicle is picked up? Well, that's a good question, Ken, because we did talk about what the creditor or a secured creditor must do after they get the vehicle. They must send notice of their intent to sell it and seek a deficiency. With respect to deficiency, there are not any legal steps before picking up the vehicle that applies with respect to the deficiency. Okay? Except you may want to think about whether there's a default, so think about what if a vehicle is picked up and there's no default? Well, there should be a default before the vehicle is picked up. And what's the default? Well, default may be outlined in the, security agreement. If it's due on the 1st, you have a grace period until the 3rd. After the 3rd, you're in default. All right, so Ken, that's what I would say, maybe a close examination of the loan agreement, retail installment contract, whatever you want to call it, security agreement, to see when default occurs. And I guess the borrower would need to be in default before this starts taking place. I mean, it would be unlawful for a creditor, without authorization to just take a car from a borrower who is not in default, right? So Ken, thank you for that question. That's a great question. Kyle, I think we just sort of talked you up, Kyle. This next question, Kyle says, there's a popular strategy that most car loans are not really loans. They are retail installment contracts. So it is inaccurate to report them as an auto loan on the disclosure. The whole idea sounds good, but how do you execute it? The lawyers I've talked to about it laughed and said there's not a judge anywhere they will rule in favor of that judgment. Okay, so we're gonna have to break this down a little bit. And Cal, thanks for that question. So it's a loaded question. I guess all these questions are somewhat loaded, but this one is sort of loaded. And it's talking about there's some people out there saying, hey, a car loan isn't a car loan, so if it's on your credit as a car loan, that's inaccurate. It should be a retail installment contract. And so, they're breaking the law. So, I'll be honest with you, there's some truth to that, but the truth is, there's some distinctions. There's a loan agreement, but think about it. A loan agreement can take many forms. It could be a promissory note. It can be a retail installment contract. Once that money is given out and there's an agreement to pay it back, that's a loan. So this technique that you're speaking about, Cal, is sort of like splitting hairs, because think about it. A retail installment contract is technically a loan. So to say that a retail installment contract is not a loan would signify there's no money being dispersed. But the reason why I said it has some truth to it is because you can successfully say that it's inaccurate. If you have an agreement, a document that says one thing, retail installment contract, but it's being reported as something else, then you could technically try to say that's inaccurate on the credit report to deem it that. I see that a lot in the credit card disputes. Sometimes they won't list a credit card account as a revolving credit and may call it something else, and that is successfully used as a basis for inaccurate reporting to get a deletion. But with respect to this, like I said, I have seen it work, splitting those hairs, but this is not something you would use to litigate under the FCRA, in my opinion. And so that's why lawyers that you may have contacted laugh about it, because this kind of splitting hairs, judges don't want to see in their court. So I would not, and you would not find many attorneys that would be willing to litigate a repo deficiency based on this theory alone. That's not, that can be very dangerous for a person, because the secured creditor can come back and counterclaim for that balance. So no, that's very bad technique. Again, I understand some people talk about this a lot and focus on it, but again, that's not something I would recommend focusing on outside of the UCC, because really the deficiency is guided by the UCC. So this splitting hairs with the credit reporting, even if you were to do a case like this, it would be against the CRA, but I would not recommend it. All right. Thanks a lot, Cal. Let's see. Here we go. I think we have a couple more questions then. I think we're good. All right, so Yolanda, thank you for this question. If someone made a payment arrangement for a repo not knowing the deficiency laws are there as a way to get out of the payment when the car was sold for $500 but requesting over $12,000, the payment arrangement was made after finding out the car was sold for $500 at auction. And how should it show on the credit? If the reporting, and I'm sorry, some of these, the way it's typed, a lot of people, when they type things, it doesn't come out the way they intend, so I'm trying to put it together correctly. It's reporting the wrong amount owed in payment history on credit report, I would assume they're talking about. Can we get a removal or just an update to the credit file? All right. This is a real good question, and this really involves, and Yolanda, thank you for this question. This involves a situation where a repossession took place, there was a deficiency, and the consumer, the borrower, ended up making an agreement with the secured creditor, not knowing whether or not the UCC laws were violated in getting to that deficiency. I can't say I fully understand this question, because the facts that are given to me the car sold for $500 at the auction, but they're requesting over $12,000. So, you know, there's a couple of ways this can go. What if they did everything right and that $12,000 is the proper deficiency? Because you have, let me tell you a situation how this can occur. I know you're thinking like, how can a car sell for $500? Well, what if it was in an accident? What if it was in an accident, the person didn't have insurance, or it was in an accident, the person had insurance, but it wasn't sufficient, and there was no gap insurance. So there are scenarios where a car may reasonably sell for $500. It could be just some metal. It may be just the only thing good in it. It may be the engine. So this could happen. And there could be a bona fide $12,000 deficiency, right? And in the collection process, the borrower could agree to pay that. That could be no problem, or it could be a huge problem. What if everything was not done correctly and the person couldn't claim a deficiency and the borrower made an agreement on top of that? Well, that's when it gets tricky, because you can waive your rights by agreeing to something. So say if the bank or the secured creditor technically, legally otherwise couldn't collect on that deficiency, but because the borrower contractually agreed to pay it, now they can. So so that's a tricky one. That one has to be examined on a case-by-case basis. You know, was there any fraudulent inducement into that agreement? So it really, if you can understand where I'm coming from, that's one of those scenarios where it would be good to get a lawyer involved to sort of help look at the facts and the law and analyze, you know, solution here. All right. Yeah, that's it. So those are the questions we have for now. Great questions. Thank you, Yolanda, Cal, Ken, Shayla, Brenda, Eddie, Kathy. Thank you all for those questions. I'm going to post this. What you can do is look in the description. Go ahead and get that repo deletion package. Very important to have these tools. And I put all of these things I talked about today, I put together in a package that can be utilized for consumers. It's designed to do it yourself, to deal with these repossession deficiencies. When I say deal with them, I'm talking about deleting off the credit report and stopping these secured creditors or alleged secured creditors from collecting on it. That's ultimately the position you want to be in. You want it off of the credit report, and you do not want to risk being sued or having to undergo or be subject to collection measures. Any other questions? Look,